You just concluded your divorce and you have a living trust that was set up with your ex-spouse. You may feel relief and the hope of a fresh start. But here's the thing, your estate plan still ties you to your past marriage unless you act. If you leave that trust unchanged, you expose yourself to risks you neither want nor expect. If you fail to update your living trust after your divorce, you risk the following problems. First, your ex-spouse may still benefit. If your trust names your ex as a trustee, successor trustee, or beneficiary, then after you die or become incapacitated, your ex may control or receive assets you no longer intend. Under California law, divorce does not automatically remove all roles or interests your ex-spouse holds in your trust. Courts treat trusts differently based on how they were created and funded. Next, there are community property issues. California treats most property acquired during the marriage as community property, subject to equal division at divorce. If your trust holds assets you acquired during the marriage, or even separate property that was commingled, the court may treat those trust assets as marital and subject to division. What that means is that a trust you assumed shielded your assets may not. Your original intent may not be as strong as you'd like it to be. For wills, California automatically revokes provisions in favor of an ex-spouse. But for trusts, the protections are weaker. The statute for wills applies clearly, but trusts often require explicit amendments to reflect your changed wishes. There's also the issue of unexpected control risks. Suppose your ex remains co-trustee or successor trustee in your trust after your divorce. That means your ex may now hold power over distributions of the trust, manage assets when you are incapacitated, or decide who benefits. That degree of power may conflict with your new vision for your life and your loved ones. Also consider the issues surrounding mistitled or misbenefited property. What do we mean by this? Well, after divorce, you may assume ownership changed, but if trust assets are still titled in the trust with both you and your ex-spouse named, you may unintentionally preserve your old structure. A house or account may stay inside the trust under the old terms. That leaves your heirs facing confusion or unexpected claims. Here are several other rare but real issues. Suppose after your divorce you remarry or form a new partnership. If your trust still names your ex or holds community property, you may inadvertently leave your new spouse or children from a new relationship without clear benefit or protection. Another situation might be that you had separate property before marriage, put it into a joint trust during marriage, and post-divorce you assume that property is safe. If community funds improved that property or you failed to document the origins, that property may be considered marital and divided. And here's still another scenario. Let's say your trust holds business interests or retirement accounts and your ex-spouse remains beneficiary or trustee. Upon death or incapacity, you may find yourself subject to financial or management interference by someone you no longer share a life with. Here's still one more issue many don't think about. If you become incapacitated, the successor trustee you originally named during your marriage may still be your ex-spouse. If you suffered a serious injury or illness, your ex may legally step into that role and manage property, financial decisions, healthcare funds under related powers. That situation may conflict with your current reality and relationships. To avoid all of these issues from causing stress or problems, do the following immediately. First, locate your trust document and review its terms. Identify all trustees, successor trustees, beneficiaries, and the list of trust assets. Note if your ex-spouse appears in any of those roles or benefits. Next, retitle or remove the trust if it was a joint trust with your ex-spouse. If you created a joint revocable living trust with your former spouse, you will generally need to dissolve it or split it into separate trusts for you and for your ex. Courts treat joint trusts funded during marriage as community property. The next thing to do is to amend your trust to remove your ex-spouse from all roles. Name a new successor trustee and new beneficiaries if your ex-spouse is still named. You also must update power of attorney, healthcare proxy, and other estate planning documents that may remain in the old structure. Next, retitle assets and update beneficiary designations for all real property, bank and brokerage accounts, retirement plans, life insurance policies, and other non-trust assets. Double-check all the titling and the beneficiary designations. Make sure they reflect your post-divorce wishes. Even if the trust is revised, the underlying asset title or designation may still tie you to your ex. You will now want to document separate and community property history to avoid commingling issues. If any trust assets were acquired before the marriage, by inheritance or gift, make sure there is a clear record showing separate property origin. If you used community funds to improve, maintain, or pay down mortgage on property held in trust, then recognize and document those contributions because courts may treat them as community property. Look, it goes without saying that it is always best to meet with a California estate planning attorney to do all these things. Your situation may involve subtle facts about when the trust was funded, what assets it holds, and how property character changed. A skilled attorney will walk you through the risks, ensure your amendments comply with California law, and help you execute the changes correctly. Once you do all the above, make sure to notify your successors and advisors. Let your new successor trustee, financial advisor, CPA, and any executor or agent know about the changes. Make sure everyone has updated copies of the trust document and knows the new structure. If you are one of our clients, upload all of your new updated documents into your secure client portal. This way, the people who you trust and are counting on will have access to your new and updated instructions. And remember, nothing is valid until you sign and fund all changes to your trust and other estate planning documents. Once you amend the trust and update titling and designations, you must execute the documents properly and move assets to align with the new structure. An amendment is only effective if properly signed, notarized if required, and then funded. Here's the thing to remember. You have ended one chapter of your life and opened another. Finalizing a divorce means reimagining your future and reclaiming control of your estate plan. Take charge of your living trust now before the clock ticks on unintended exposure. By reviewing your trust, removing your ex-spouse from all roles, retitling assets, documenting separate property, working with a California estate planning attorney, and executing the changes immediately, you protect your legacy, your family, and your future. Comment below or send a private DM if you have question. Also, please share this video and information with someone you know who just divorced and still has a living trust. Hopefully, they'll find the information helpful. If you found value, please like, share, and comment. Also, for more free information, see the other videos and playlist. We also have shared a few links to other articles and our website in the description. Thank you for your time and attention. Between now and the next time we chat, enjoy the journey and never stop making each day your masterpiece.